I want to talk to you a little bit about Article 15s. In the Navy, it's called Captain's Mast, and in the Marine Corps, they just call it non-judicial punishment, which is consistent with what's in the Manual for Court Martial. What's an Article 15? One, it is that. It's non-judicial punishment at the unit level for some violation of the UCMJ. But the Article 15 is more than just an action, an administrative action. It's also a forum, meaning the government has a dispute with the service member saying that they violated some thing with respect to the UCMJ, and now you will resolve that dispute in front of the commander as opposed to going to court in a court martial. And so it's a forum, and you actually have choices with respect to that forum, which is the subject matter of this little talk that I'm having with you. And the choice is whether or not you should turn it down and request trial by court martial. And what I've seen with Article 15s is, and I'll just use Fort Hood as an example, units will hand out Article 15s hundreds a month. And when I'm saying a unit, I'm talking about a battalion level unit, brigade level unit, handing out Article 15s for any variety of things, whether it be drug use, hot urinalysis, disrespect to superiors, a litany of things that you can get an Article 15 for. And in many cases, what you find is they're sent over to TDS, and they have certain intake days for Article 15s. And when they're at TDS, they'll stand in a line for a while. I've been for the TDS to visit clients for other matters, and I've seen lines all the way out to the parking lot. And what does that mean to the service member that's standing in that line? Well, that means they're going to get about 15 to 20 minutes to talk to an attorney about their Article 15. Is that enough time for the attorney to review the evidentiary packet and talk to the client about their specific case? Probably not. Many times these cases require a little bit more of a deep dive into the nuts and bolts that underpin the Article 15 in and of itself. And so that's what I bring to the table when I look at these things. I want to see whether or not they have evidence beyond a reasonable doubt to prove this Article 15. That is the standard in the Army. It is proof beyond a reasonable doubt. It's the only service that has that level of proof. The remaining services have a lower standard. And so with our Army clients in particular, we take that very seriously. And what we want to do is see whether or not the government can prove what they've put on that piece of paper. And if they can't, we're concerned about the forum of going in front of a commander and arguing the case. Because even if you feel like you have evidence in support of your case and that there's not enough evidence supporting the action that's being taken against you, commanders will oftentimes impose that Article 15, not thinking about the burden of proof. But you know who has to think about that burden of proof? A jury of your peers, a panel of your peers in a courtroom. And so in many cases, when we look at these Article 15s, that is the standard that we're looking at, and we'll advise the client accordingly. And of the clients that we've advised to turn the Article 15 down, our soldier clients in particular, those cases have worked out very well for the client themselves. And so it's important to have someone that's seasoned and experienced to take a look at these Article 15s and give the right advice to the service member, whether to accept the forum and fight it in front of the commander if they feel like they're going to get a just result, or to turn it down and request trial by court martial because they feel that's the only place where they're going to get a just and right result.